further leave to remain, FLR applications being refused by Home Office, and individuals being put on immigration bail. This is a common occurrence that is happening currently right now. I have seen several applications where decisions where individuals have been refused their FLRs on whatever grounds they had been filed. There is a lot of what Home Office has observed is there is a lot of abuse of this further leave to remain. Anyone who doesn't have any permission, they are just abusing the immigration rules, and they try to file this further leave to remain without any basis, giving any reasons, just to buy time to live in the UK. And that is not the very reason. I have been explaining about this for a while now, more than a year before this now also, and maybe 2 years from now also. I already kept on making these videos about not to file the further leave to remain application unless there is a genuine need, there is a reason for that. So even in my previous videos, I remember that last year also, about 1.5 year back also, Home Office used to have a very strict stance on this when, let's say, students trying to file FLR just to further leave to remain, just to live in the UK, giving whatever reasons, excuses, just to buy time. And at that time also Home Office, so this is the difference in practice that I've seen. At that time Home Office could keep the application on pending for a long time, 1 year, 1.5 year, I know 2 years also, and no decision, no answer would come. And suddenly, after 2 years, after 1.5 years, the decision would come, and at that point, the individual would be put on immigration bail directly, stating your application has been refused and you are on immigration bail from today, from the date of this decision. So, and with immigration bail, and that has changed to now what they are doing. I've seen refusals which have come recently for applications filed in April. So from April till November, about 6 or 7 months. So within 6 to 7 months, and even less than that, I know there are FLR applications which are decided in 3-4 months also, where Home Office is considering it that it's just a frivolous application, just to buy time, giving any health reasons, anything, any nonsense in their words. Basically, they would not say it clearly, but that's what they mean when they are writing the refusal letter. Whatever health reasons you are asking for, anything reasons you give, just to buy time, which is very much evident from the application, from any documentation that you may have produced, or from any personal statements that you may have given. I have been explaining this in my previous videos also over a period of a year now, that don't file these FLR applications just to buy time. Whether you are on a student visa, skilled worker, graduate route, whichever points based application you are on, and you're just trying to buy time, don't use them unless there is a reason. FLR is a situation where you can only try it, you can only file it. We have done FLR applications, it's not that we have never filed FLR applications where there is a genuine need. For example, I remember a visitor, a lady was stuck in the UK, she had a British partner, she was on a visitor visa, and she got pregnant, and after that there were some complications. They provided some letters from their private hospitals. Anyways, she didn't have access to NHS, so definitely they were taking private treatment, and with that the medical, whoever the GP or the health practitioner had confirmed that there were some complications with their pregnancy and she was unable to travel. So that is the reason where we did get about 6 to 8 months. I think they gave it till the due date, and some more months over that. But then in such cases, yes, Home Office will exercise discretion and will grant, where they see a third party independent evidence, usually from a medical practitioner or whatever that is. For example, let's say the applicant is hospitalized, there is an accident, and whatever the medical advice is that they cannot travel. So FLR, further leave to remain, should only be filed where there is a genuine need, there is a reason beyond the control of the applicant, not that just the applicant wants to live in the UK. So if in such cases the applicant cannot travel outside the UK for whatever the medical reasons are, in such cases, yes, it is fine. Home Office would accept that. We have got many approvals on those fronts where there are medical reasons or any other reasons why the individual is stuck. Applications where adult dependents have come, adults have come, older people have come to meet their family members in the UK, and they are on any type of visa, say visitor visa, temporary permission in the UK, and let's say several cases where people are unable to travel for arthritis reasons, any other, usually it is only medical reasons that I have seen. Home Office takes things seriously on the FLR front. other than that, FLR others, whatever the forms they name them. So on those, they would only consider if there is a genuine reason why the applicant cannot travel outside the UK, why they cannot leave the UK at the end of their permission. They would consider it. But in case of students, skilled worker visa holders, say students whose permission is due to expire, they don't have any option, they didn't find a job or anything, or they didn't complete their course of study successfully, or otherwise they were being withdrawn from the course. In such cases, Home Office is not going to extend these FLR. They are not going to give you permission. They know that this abuse of immigration rules, basically what you are trying to do. Even in case of graduate route and you didn't get your skilled worker certificate or sponsorship, or you didn't get a sponsor, you're just trying to buy time. They are not going to approve such applications. For or a skilled worker whose employer has lost license, or the employer has made you redundant, and your permission has coming to an end, or it has been curtailed. Just by virtue of these reasons, Home Office is not going to give you further leaves. Please understand that very well. And Home Office has been observing this abuse over a period of time. I think over last 1 year it has been happening. Care homes losing licenses, students not completing courses. All these issues came around on this PBS area, and Home Office has been observing all this further leave to remain. Fee waiver is a completely different discussion. I wouldn't even talk about it here. But yeah, so with FLRs, individuals applying for this just to buy time, Home Office has been very tolerant, and they were taking time in making decisions. But now I think they've got to it. They have decided what they are going to do with all such applications, and they have started refusing. I think 7 months and all. I have seen decisions which are coming this month from April applications, I think, and even which were fined even after that, decisions are coming with refusals. And the refusals also state that you are on immigration bail from today. For example, if the refusal comes today, then it would say from the date of this decision you are on immigration bail. You cannot switch on to a skilled worker visa or for any visa for that matter once you are on immigration bail, because as of today you don't have any permission in the UK, nothing doing. There is no section 3C also, so there is no switching, changing onto any other visa category. That will not be allowed. Any permission that you will be filing will only be outside the UK. So this is my wise advice to everyone. Anyone who is thinking of doing that, don't do it just to buy time. If you have a genuine case, then better file that application pending whatever it is. For example, we have done many successful applications where graduate route holders, they don't have a decision whether there is a reset. There is a reasonable time, I think up to 60 days, up to 40 to 60 days. Even after the end of their permission, we were able to do it successfully. If they had a reset, sometimes results were delayed. Yes, in that case, you can file the application. Rather than filing FLR, there are options where you can speak to us, immigration lawyers, and get representation, and we can request the Home Office to keep the application on hold. Filing the correct application is what is important, not just this intermediate application. Intermediate applications is what Home Office does not like. So that is one. If you are trying to switch on a skilled worker visa from whichever permission you are on to, you can apply. Let's say you don't have a cause, or even the employer has given you the offer letter but they don't even have the sponsor license. We've done many cases where employers didn't have a sponsor license. We filed the application, asked the Home Office to keep the skilled worker application on hold, filed the sponsor license, got the license, got the certificate of sponsorship, and then send the cost, assign the cost, and send the cost reference number to the case working team, and they have considered reasonably. Throughout this period, your Section 3C leave is protected. So there are these applications which are pending for some reason, pending a result, pending a reset decision for the graduate route, or pending a certificate of sponsorship or sponsor license and certificate of sponsorship. It is possible. Speak to immigration lawyers, they should have experience doing that. We've done many of these cases where the correct application is filed, and requesting the Home Office just to give some more time to get the certificate of cost or either certificate of COS sorted out, or let's say if the result is not yet out, reset is going on, or whatever is there, challenges with the university and all those cases can be sorted. A pending application can be filed. I know they may decide to make it invalid, because I know one of those reasons for all these requirements which we ask to keep them pending, they are in the validity reasons. The Home Office has the decision, has the option to refuse them as invalid. But what we have seen from practice is, with us, every time they have been reasonable, they've kept the applications on hold for a reasonable period of time. So definitely, if you are in such situations, speak to us, book a consultation with us. We charge for our consultation. We don't provide any free advice. And with the immigration bail, this really makes your situation very tricky. You cannot do anything in the UK. You are basically just out of any permission if you are put on immigration bail with a refusal decision. One other point is, if you are already on FLR and your decision has not yet come, whoever filed it, lawyer filed it, you filed it, or whatever has happened, if you definitely switch on to the correct route, whatever, for whatever reason you filed that FLR, that is not relevant. The point is, if it is pending a decision is not, a refusal decision is not yet made on your FLR, then file your skilled worker application and vary that application. File your whatever graduate route application, whatever you are eligible for, whatever you are planning for, whatever you were looking out for, you are buying the time. If you already filed FLR, try and vary that application. Speak to immigration lawyers. You can vary that application also. If it is pending decision, if a decision is made, nothing can be done about the FLR. But if a decision is not yet made, you just filed it, then yes, there is a possibility of varying that application, filing whatever relevant application you have, skilled worker, graduate route, student visa, whatever that is. So yes, you can book a consultation with us or speak to any other immigration lawyers. And this is what I wanted to update. This is what is latest happening in the industry that I've heard of, and I've spoken to other lawyers, and I have also seen several refusals. So be careful on that, and thank you very much for watching this video.